Hi everyone. Thanks for tuning in again to another episode of What Did the Federal Court Say? And this time we have Sue and Iwi with us.
Hello, everyone.
Hi.
Hi. And the topic of discussion today is on the Federal Court's decision on detentions under the Prevention of Crime Act 1959, particularly on two cases. So first, we will be talking about Rovin Joty's case, Rovin Joty against Lembaga Pencegahan Jenayah and another. And secondly, Zaidi Kanapiah's case against ASP, Karu Fairuz and other cases. And since today we are discussing these two cases, let's take it slow and we will be addressing these cases in turn. And before we start, as usual, drop us any questions you have on our topic today, which is on detentions under POCA, in the comment section below, and we will address them later. But before we start discussing about the cases, I would like to brief everyone about what POCA is. POCA is actually the abbreviation of Prevention of Crime Act 1959. It was initially enacted to control and prevent organized crimes by targeting criminals, members of secret societies, terrorists, and other undesirable persons in Malaysia. And it grants the police power to arrest and detain an individual without trial up till 60 days. And these 60 days can be broken down into three. So first is the preliminary arrest for 24 hours. Second, an extension of 21 days with a statement in writing signed by a police officer. And third, a further extension of 38 days, so totaling up to 60 days. Then following this 60-day detention, the detainee would have his or her case heard before the Prevention of Crime Board, which has the power to sentence the detainee to not more than 2 years and may extend if further detention is necessary to protect public order, public security, or prevention of crime. And the board also has the option to issue a restraining order or discharge the detainee. All right, so turning to the first case, which is Rovin Joty's case. What happened was Rovin Joty was, of course, detained under POCA, and he challenged the constitutionality of Section 15 capital B of POCA. Section 15 capital B is an ouster clause which stipulates that courts are precluded from judicially reviewing and scrutinizing the decision of Prevention of Crime Board unless by reason of procedural non-compliance. So what did the federal court say? Sue, would you want to tell us what did the majority decide in this case?
Yeah, sure. So just now, Jack, you mentioned that this case is on Section 15B of POCA, and you explained what is Section 15B of POCA. So the question that is asked in this case is whether Section 15B is constitutional. So if Section 15B is constitutional, then it limits the ground of challenge by detainees. But if it's unconstitutional, then the detainees can challenge their detention on any grounds. So for this case, majority of the judges in Rovin held that Section 15B of POCA is not unconstitutional with the following reasons. So number one is that Article 4.1 of Federal Constitution states that the Federal Constitution is the supreme law of federation. And it provides that any post-Merdeka law inconsistent with the provision of the Federal Constitution is void. And pursuant to Article 4.1, a written law may be invalidated by the courts under various grounds. But POCA is not inconsistent with Federal Constitution, given that POCA was enacted under Article 149 of the Federal Constitution. And Article 149 of the Federal Constitution empowers Parliament to pass special preventive laws such as POCA. Therefore, Section 15B POCA derives its force of law and validity from Article 149 of the Federal Constitution, and this can be discerned from the preamble to POCA. And the Federal Court in Rovin's case also state that, because another issue brought up is that Article 15B and Roach doesn't comply with the doctrine of separation of power. But the federal court states that the executive, legislative, and judicial function, which are the three branches, are overlapping and cannot be separated. So to what extent the doctrine of separation of power applies depends on the provision of the federal constitution. And no provision of the law may be struck out as unconstitutional if it is inconsistent with the doctrine. So it is Parliament that confers the judiciary with the extent and manner of powers and jurisdiction through the federal laws. And so, Section 15b of POCA does not enroach on judicial power, and neither does it breach the doctrine of the separation of powers between the three branches, because it still vests judicial power with the courts. And this case also touches on the basic structure doctrine, but this basic structure doctrine was discussed in details in our previous session with Shara and Beatrice in Maritime case. So in avoidance of being repetitive, we will not touch on this issue in depth, but the majority judges in federal court held that basic structure is not applicable in Malaysia, and therefore upholding whatever was discussed in Maritime case. So basically that was the summary of what the majority judges in Rovin's case spoke on.
Okay, thank you, Sue. Right, Iwi, so what did the minority judges in this case say?
Hello. Right. So what the minority say in this case is we have to look at the judgment of the federal court judge Nalini. She was the judge who delivered the dissenting judgment. So what the minority decision is basically, in contrary to what Sue has just told us, what the federal court say in the dissenting judgment is that Section 15b of POCA is actually unconstitutional. And because the fact that it is unconstitutional, it is liable to be struck down, and it's an invalid act of parliament. So why we are saying that it is unconstitutional? In essence, what the federal court said is that it is an austere provision which seeks to preclude the jurisdiction of the courts to examine any act or decision done and made by the Prevention of Crime Board. So what the Prevention of Crime Board usually do in a very general sense is that it decides whether or not an individual can be detained. If the board says that it is lawful, then it means that that person can be detained, and the court wouldn't have any power to say that, look, hold on, this is unlawful, and so this person cannot detain. What Section 15b is saying that the judge cannot do this. So in essence, the dissenting judgment focus on Article 4, subsection 1 of the Federal Constitution, which is a provision that provides for the constitutional supremacy that we adopt in Malaysia. So what is constitutional supremacy? It essentially means that the Federal Constitution in Malaysia has the superior and greatest power or authority on this Malaysia land. This means if the Parliament decides to pass any act of Parliament that is inconsistent with what has already been stated in the Federal Constitution, the Constitution prevails, and the act of Parliament would be liable to be struck down. In essence, it strikes down Article 4, subsection 1 of the Federal Constitution strikes down any law that is inconsistent with the Federal Constitution. This means that if there is an act of Parliament which has the effect of attempting to remove the power of the courts from hearing a case, Article 4, subsection 1 can be play a part and to challenge that particular act of Parliament, which is inconsistent with the Federal Constitution. So if we look at Rovin Joty, we focus on Section 15b of POCA and why it is inconsistent with Article 4, subsection 1. In Rovin Joty, what the federal judge Nalini say is that it imposes a blanket prohibition against the judiciary. The court is completely prohibited to review or scrutinize any decision made by the Prevention of Crime Board on any decision regarding the detention of an individual. This is a very drastic consequence to individual that's going to be detained. So it is an express and direct encroachment of judicial power, according to what the court says. as Section 15B in effect takes away the entrenched power of the court to review a law that is unconstitutional. Holding Section 15B as valid would do injury to the doctrine of separation of powers, which I'm sure many of you have already heard of, which is the three branches of government, the executive, the judiciary, and the legislature should be separated and act as a check and balance over the other to make sure the power is not overused and there's no one branch of the government over the other. So in essence, it basically is different from what the majority says, and it says that so long as there's a provision that's inconsistent with Article 4, subsection 1 of the Constitution, it is unconstitutional and it should be struck down. And so, in this sense, Section 15B is not valid. Yeah, so that's what the dissenting judgment says.
All right, thank you, Yue. So I guess if you have any questions, we will address it at the end of this session. So let's quickly move on to our second case, which is the case of Zaidi Kanapiah. What happened in this case is that Zaidi Kanapiah was initially detained by the Malaysian Anti-Corruption Commission in a specific investigation on corruption within the police force. He was later released on the MECC bail, but was later arrested again and taken into immediate custody by the police under POCA. Zaidi asserted that he was one of the material witnesses in the MECC investigation and that he was detained again by the very police officers who were the subjects of that corruption investigation. And the basis for the detention of Zaidi under POCA was purportedly pursuant to the Common Gaming Houses Act 1953. And yeah, some of you might wonder why and how is this Gaming House Act connected to POCA. So under POCA, specifically item 5 of the first schedule, it provides that all persons involved in the organization and promotion of unlawful gaming constitute a registrable category of persons for the purposes of POCA. And on 14 October 2020, Zaidi was produced before a magistrate who ordered the first remand for 21 days. Right? This first remand was to expire on the 3rd of November 2020. However, before the expiry of this first remand, on the 2nd of October 2020, Zaidi filed an application for habeas corpus. Application for habeas corpus is an application to determine whether the detention was lawful or not. Right, but on 30th of October 2020, Zaidi Kanapiah once again appeared before a magistrate for a fresh remand order, and this second remand order was given for a period of 38 days. And there were actually 3 issues raised in this case, but our focus will be on whether Section 4 of POCA is unconstitutional because the magistrate had no choice but to issue the 21-day remand order under this provision when a written and signed statement of a police was produced to the magistrate. Right, so Zaidi argued that such compulsion upon a magistrate by the executive, which is the police and the public prosecutor, violated the doctrine of separation of powers. So what did the federal court say in this case? Sue, do you want to start first?
Yeah, sure. Okay, so I think Zaidi case is more interesting compared to Rovin's case because Zaidi case touched on how a magistrate should act when faces an application by the police to remand a person under POCA. So does the magistrate act automatically to rubber stamp the remand, or there are substantive matters for the magistrate to consider before giving the remand order? So in other words, does the magistrate have a discretion to refuse remand? So under Section 4 of POCA, the magistrate shall, on the production of a statement in writing stating the grounds for believing that the name of the person should be entered on the register, remand the person in police custody for a period of 21 days. However, if no written statement is produced and no grounds on which the person is lawfully detained, the magistrate may direct his release. So in practice, what happens is when a person is brought before the magistrate for POCA remand, the magistrate will usually just automatically allow the remand application without really asking questions to the arrested person or the lawyers or the police. But the majority in the federal court in Zaidi case actually held that magistrate has a discretion during remand application and not really act as rubber stamp. So basically, it's saying that the magistrate have to look into some requirements before allowing the remand application and not allowing automatically. So firstly, the magistrate must satisfy that the arrest was carried out in accordance with law, and this is done by questioning the person arrested and looking into the police diary. So the magistrate have to ask the person if he was produced before the magistrate within 24 hours of arrest, and if the person arrested was informed of the grounds of his arrest by the police officer making the arrest. Then you also have to ask whether before commencing any questioning or recording of any statement, if the police officer have informed the person his right. Like for example, can let him know that he can communicate with a relative or friend to inform his whereabouts, or maybe to get a or to communicate with a legal practitioner of his choice. So after asking all these questions to the arrested person, the magistrate also have to look into the police diary to see that if there is sufficient facts to support the arresting officer's belief that the grounds existed which would justify the holding of an inquiry into the case of the person arrested under Section 3 sub 1 of POCA. And then the grounds should also corroborate the belief that the person is a member of any registrable categories. For example, if the person is a gang member or if the person is a human trafficker. So those are the registrable categories in Part 1 of the first schedule of POCA. And then if there is, then the registrable category in question must be clearly stated in the police diary. So if the magistrate is not satisfied that the arrest was carried out in accordance with law, the magistrate should reject the application for remand, create the grounds for believing that the name of the person should be entered on the register, like the preventive of crime register. So there are a few relevant matters to be considered. I'm just going to name a few. For example, the magistrate have to consider whether there are sufficient facts and particulars to show in what manner the person arrested has acted or is about to act in relation to the matter for which he has been arrested, or whether there are sufficient facts and particulars to show in what manner the person arrested is a member of a substantial body of persons to cause a substantial body of citizens to fear organized violence against person or property. So if after the magistrate look into all those considerations and thinks that these are not satisfied, then the magistrate should direct the person to be released. But if all the necessary ingredients have been satisfied, the magistrate shall make an order for the remand of the person. And then the magistrate should also record the reasons for his decision in a concise and comprehensive manner. So in Zaidi's case, the court finds that there was no evidence to indicate that the magistrate had applied the guidelines to ensure strict compliance with legal, procedural, and constitutional safeguards, and therefore the detainees were to be released and they allowed the appeal of the detainees. So what essentially means that, because all along it has been presumed that a remand application would automatically be granted by a magistrate as long as there is a production of statement by a police officer. But with this new case, with this Zaidi case, it's basically saying that the magistrate are now not expected to act mechanically when hearing remand application. They don't have to just automatically grant it, but they have to actually look into all these considerations before actually allowing a remand order. So that's the gist of what the federal court said.
All right, thank you, Sue. Yeah, Yui, would you like to continue with the minority perspective on this?
Right. Hello. Okay. So, what the dissenting judgment say was again different from what the majority decision says. The in Zaidi Kanapiah, the minority decision was delivered by Tengku Maimun, the Chief Justice, and also another federal court judge, Zaria. So, like what Jacqueline has already introduced just now, we have to look at the wordings of what Section 4, subsection 1 of POCA says. If we look at the wording, in particular, the legislation used the word must. It basically says that if a police officer sign in statement of writing saying that he has grounds to believe that that person, that particular individual, shall be detained under POCA, the magistrate would have no choice but to issue a remand order. The first one is for 21 days, and if after that the police officer or the public prosecutor again sign it with a statement of right in writing stating that this period of detention shall be extended, the magistrate would again have no choice but to grant a remand order for a further 38 days. So what POCA, the effect of POCA, of Section 4 of POCA, is that the magistrate does not have any power to decide whether or not the remand order shall be granted. Whether or not the magistrate thinks that it's valid, for some reason the remand order shouldn't be granted, it would have no choice but to grant it because of POCA. So because of these mandatory wordings, what the dissenting judgment is saying that it is unconstitutional because it basically encroached the judicial power of the court. So in dealing with this, we have to also bear in mind the fact that POCA is an act of parliament enacted under Article 149 of the Federal Constitution. So what the Article 149 of the Federal Constitution is saying that if it falls within one of the provisions there for POCA, is if it falls as a organized crime, then even though a provision under Section 149, it violates the fundamental liberties of a person, and in particular Article 5, 9, 14, I can look at the wordings of the Federal Constitution, then even though it is inconsistent with the fundamental liberties, POCA is still valid by virtue of the fact that Article 140 is enacted under Article 149. But if we look at the dissenting judgment, the Chief Justice Tengku Maimun says that even though POCA is enacted under Article 149, the court can still have the power to scrutinize the POCA and see whether or not it's valid. So then the court proceeds to consider the question of whether or not POCA is, Section 4 of POCA is valid or not. So what the court says is that because of the fact that magistrate would not have any power but to issue the remand order under POCA, it violates the separation of powers. Because if we follow the doctrine of separation of power, judiciary is basically a branch of government that acts as a check and balance against as executive and legislature. But in this case, if Section 4 is valid, it means that the judiciary basically have no power but to follow what the executive says. So it violates the doctrine of separation of power and it's unconstitutional. And by virtue of the fact that it is unconstitutional, it therefore cannot be regarded as a valid federal law under the definition of Article 121, subsection 1 of the Federal Constitution, which basically provides for the jurisdiction of the court. And because of all was stated just now, since the remand that was issued in Zaidi Kanapiah was made on the basis of an unconstitutional law, the detention of the appellates in this case was unlawful. And so in essence, what the dissenting judgment is saying is that Article 4, Section 4 of POCA is unconstitutional and it's not valid, not a valid act of parliament.
Okay, thanks, Yue. So yeah, that's really a contradiction between the majority and the minority point of view. And let's now move on to the Q&A. And before we look at questions from the floor, let me ask a few basic questions. So can the both of you tell us how is these two cases different? Because it's both decided on detention under POCA, but what are the differences that make these two decisions actually concluded the same but different?
Okay. Well, Rovin Joty touches on Section 15B So it touches on the ouster clause, whether whether the court has a judicial power to actually review the decision. Whereas Zaidi talks about the procedure before the magistrate court, which is under section 4 of POCA. So both touches on different issues, even different issues, whether these two clauses are constitutional or not, and it's different angle in terms of the question posed to the court. But regardless, both courts also held that section 4 and section 15 are constitutional. So in that sense, it's the same one, I would say.
All right. So, am I right to say that you're trying to say that the difference is that there's two provisions being challenged in court, which is on a different subject matter. One is on the magistrate's power to give remand order, and another one is on the ouster clause, right? Because the decision of the Prevention of Crime Board cannot be reviewed by courts, if I got it correctly.
Yeah, basically it's that. But one thing good about Zaidi is that they are basically saying that the magistrate is no longer a rubber stamp, just automatically allowed. So the magistrate have to look into all these bases compared to last time, where they don't even have to consider all these requirements they have met.
Okay, thanks, Sue. Okay, we have questions from the floor, right? The first is, as POCA is a preventive law, are there preconditions in the usage of this act?
I'll take this one.
Okay.
Sorry. So the precondition for someone to be, arrested or detained under POCA is basically to make sure that the act that was detained, the act that the person was conducted falls under the preamble of POCA. So if you then also have to look at whether it falls under the category of offences in POCA. So which is Schedule 1 of POCA, that you have to look into whether it actually falls into the category in the preamble of it. And then now the court is basically saying that it's also other than organized crime and human trafficking, it's also said that it can be used for organized crime, including online gambling syndicates. So that is, you have to fall within all this first.
I see. Okay. The next question from Izzy. The federal court stated that preventive detention prioritizes security over individual liberty, and I believe this is in Rovin Joty's. So what is your opinion on this statement? Does it justify POCA to continue to exist? Maybe Iwi can start first.
Yeah, I can take this one. I will give my personal opinion on this. In particular, if we look at Rovin Joty, right, the case actually concerns the common house gambling acts. And I mean, if you look at the minority judgment, it says that the wording itself. So, what if you look at the recital of POCA, it says that if it's it justifies if it's a organized violation. But if I can just quickly share screen of the act of POCA, just so people can understand. Jacqueline, do you have a copy of the prevention of crime?
Yes. Let me try.
Yeah.
Haven't tried sharing screen here before.
I can try sharing.
Can you see? Sorry, that's like a million things on the screen right now. Yeah, I guess this is what you're trying to say, right? Can you see?
Yes.
Sorry. Okay.
Yes, it's this part. So if you see, it says, whereas action has been taken and further action is threatened by a substantial body of persons, both inside and outside Malaysia, to cause a substantial number of citizens to fear organized violence against persons or property, then and by virtue of this, POCA is justifiable. This is actually the very same provision taken from Article 149, subsection 1, subsection A. But if we look at the wording, it says organized violence. But if we look at Rovin Joty, it concerns the Gambling Act. And what the minority judgment is saying that act of gambling can be considered as organized crime, but not organized violence. And as such, it doesn't really, in particular if we take into account the act of gambling, it actually violates security of person. So my personal opinion to this question is that um, individual liberty should presides over what preventive detention says in the sense of the Gambling Act. So
Alright,
it
thanks.
doesn't justify POCA to exist in the sense of the Gambling Act in the case
Okay.
of Rovin Joty.
All right, thank you, Yui. So do you want to add, or should we move on to another question?
We can move on to the next question.
Okay.
I see there's a few questions.
Yeah, there's quite a few. So do you agree on remand application? The police has complied with Section 4(1)(a) of POCA. The powers of magistrate is statutorily limited and restricted on questioning and examining the grounds that support the name of the person arrested should be entered on the register, but have to grant the remand order for a period of 21 days unless the exercise of the power of arrest is not carried out in accordance with law.
So in Zaidi case, it's really spelled out that the magistrate can exercise his discretion. So the guideline mentioned by Justice Vernon in Zaidi case should be followed. And so it is a judicial act of remand. So the magistrate cannot just rubber stamp on police application. So it's different from last time where the magistrate has no judicial discretion to disallow the remand application. So the majority is correct in terms of the powers of magistrate. Yeah, so yeah, that's my view on it.
All right, thank you. And can POCA be actually used against juvenile? Any takers?
Okay, you want to take this question, or I can take this question as well?
Are you in your...
Jeremy.
Okay.
Yeah, I think Sue, if you have the answer, you can answer also. But my opinion is that we have to look at the particular act that governs juvenile also. But if Sue has any further answers to this, please.
Okay, so in POCA, there is no distinction of juvenile and adults. So POCA can also be used against juvenile, but I personally think that it's wrong because juvenile is child and should be governed by Child Act and then the Convention on Rights of Children. They don't allow detention of children without trial. And unfortunately, in Malaysia, there is no preventive law to prevent detention towards children. So the answer is, fortunately, POCA can be used against juvenile. For now, hopefully in the future, there's parliament amendments on it and say that juvenile children doesn't fall under POCA.
Yeah.
But even if juvenile can be used, but even if POCA can be used against juvenile, they should also split out adults and child and not put them together in one thing together. At least that's the bare minimum that they should do. But of course, the best is like just don't use POCA against children. That's the best one.
Okay, thanks. So, good. Last question that we'll be taking is on, instead of relying on Article 121 of the Federal Constitution, can the matters be determined by the Federal Court pursuant to Article 128 to determine the validity of POCA? Section
Perhaps I can take this one.
Okay.
First of all, just to explain on what is Article 128 of the Federal Constitution, it stipulates specifically the jurisdiction of the federal court only. Whereas what was different from Article 121 is that it provides for the jurisdiction of judiciary. including the subordinate courts. So if we see POCA and what Jacqueline has also explained just now, section 1 of POCA, we are talking about the power of a magistrate to remand a person. So since we are talking about the subordinate courts, we cannot go under Article 1 to 8 because that prescribes for the jurisdiction of federal court. And the jurisdiction of the subordinate courts comes from Article 1 to 1. And I hope this answers this question.
So do you have anything else to add?
Yeah, just to add on to it. So Article 128 and the decision in the case of Akin says that you can only go directly to the federal court to challenge a law only if you're saying that Parliament has no power to make the law instead of the power used is inconsistent with the constitutional with the federal constitution. So basically, it means that you can only file directly to the federal court under Article 128 if you are saying Parliament had no power to make POCA or any other law. It's not that you can use to say that the law is against the constitution. So that's why it was filed under 121 instead of 128.
All right. Thanks. I guess that's all that we can take for today's session. Right. So yeah, thank you so much, Sue and Yue. And of course, to our audience, thank you for spending your afternoon with us. And yes, stay tuned on our Facebook page and we will notify if we have another session coming up next week. Till then, take care and stay safe.
Right.
Bye.
Stay safe, everyone.
Bye.